none other than the mother of J.R.D. Tata. She was married according to Christian rites with R.D. Tata, a leading industrialist, and wished to have her Navjot performed in Bombay. We are told by Rusi Lala, the chronicler of the Tata house, in the biography of J.R.D. Tata, Over the Last Blue Mountain, that in point of fact, as many as 60 priests, most of them high priests, attended the Navjot in Mr. R.D. Setna's house. Mr. R.D. Setna, again being a financier and a person close to the Tata household. We are told also that Dastur Jamas Pasa, who is the chief Dasturji of the Anjuman Atash Behram, one of the 4 holiest of holy fires in Bombay, actually performed the Navjot, after which, according to Zoroastrian rites, post the wedding, everybody had a little champagne and then went to sleep, as was customary in those days. Now, the whole question arose because Mrs. Tata, now being a practicing Zoroastrian, was brought to the family Agyari in Bandra, where I became a priest incidentally. And the chief priest there said that, no, sorry, he could not admit her, because according to our law, she was a Juddin. And we must get this term again correct. A Juddin is somebody who is of a different religion. Deen is religion. Jud is judo, separate. And since Juddins, therefore, could not be converted here, she was not permitted entry. R.D. Tata, being a gentleman, decided to test this in a court of law. He became the plaintiff number 6 in that particular case. And it was really the cause célèbre in Bombay in those times. A lot of evidence was taken of a number of priests. And ultimately, the court arrived at the conclusion that there were 2 ingredients to being a Zoroastrian, not just one. At least insofar as India is concerned. One is that you need to be born of a Parsi father, the ethnic component. And the second is that you need to be Navjotit, that is, you need to become a Zoroastrian. You need to be born into the faith, so to speak. And they arrived at this conclusion by asking themselves a question which was not directly related to religion. The question they asked themselves for determination in that case was, put yourself in the place of the founders of each of the 28 trusts that were before them. Each of these founders lived in the 18th century, in the 1700s. Each of them had something in mind when they said that the benefit of these trusts would go to persons who belong to the Zoroastrian community of Bombay, the Zoroastrian Majlis of Bombay, etc. Interestingly enough, the word Parsi was not used in any one of these 28 trusts. But the question remained, and the question was, put yourself in the place of this 18th century gentleman in the early 20th century, about 150 years after he was dead and gone. And if you put yourself in his place, what did he mean by these terms? Both the judges, the English judge with some hesitation, arrived at the conclusion that he'd have meant that somebody needs first to be ethnically a Parsi before he can become a Zoroastrian. Now, interestingly enough, as I told you earlier, priest after priest was examined and cross-examined on first what the religion said what the Zoroastrian religion had to say about conversion. Most of them entered the witness box stating that the religion did not permit conversion. Every one of them finally left, agreeing in cross-examination that far from forbidding conversion, it enjoined conversion. So the first important step taken in the case was Zoroastrianism is a proselytizing religion and believes in conversion. The second step, however, had also to be taken. What about Zoroastrianism on Indian soil? And here, 3 examples were put forward. The first example was of some Pandits in the 11th century who are supposed to have converted to Zoroastrianism. The second was of Emperor Akbar himself. As you all know, Emperor Akbar was greatly taken up with almost every great world religion. And in particular, was taken up with a Sufi saint, a man called Tajuddin, and with the great Dasturji from Navsari, our chief priest, Dastur Mahyar Ji Rana. These two apparently had an influence on him that even the Christian fathers in 3 successive stages did not have on him. And it seems that when the community was told that the Sadra and the Kasti had actually been put on the emperor, there was jubilation. So far as Akbar at least is concerned, the fact that a Navjot was done on a complete Juddin and was accepted by the community was something staring at the court. The third interesting thing was some persons called the Mazagon converts, who apparently were persons who were bastard children of Parsi fathers. And it seems they were not accepted but for a technical reason. They were not accepted not because they were born of alien mothers or because they were illegitimate, but because no notice had been given to the Anjuman and things of that sort. So, we had 3 instances, and both the judges looked at these 3 instances in 2 very different ways. The Parsi judge, Davar, felt that none of them were proved on the evidence. The English judge, Beeman, felt that there was enough evidence to show, yes, that these 3 had taken place. And therefore, they arrived at divergent conclusions so far as this part was concerned. The Parsi judge, in fact, therefore held that even though the religion said, yes, please convert, in India, there was a negative custom that was proved. The negative custom being that on Indian soil, not a single conversion had taken place. And curiously enough, the Parsi judge referred to a particular judgment which said that child marriages were prevalent among the Parsi community of the day and were part of Indian customary law. Now, he relied upon this to say that since child marriages were prohibited in Persia, prohibited by the religion, one needs to have at least attained the age of puberty, which in those days was 15. Yet, obviously, that particular law had fallen into desuetude here and was replaced by an Indian customary law, because then we took our cue from the majority community and allowed child marriages. On a lighter note, my great-grandfather was married to his first cousin when he was 5, and there was a delightful picture of the 2 of them on elephants in Surat, which unfortunately has been lost. Also, interestingly enough, because of this, a Parsi, Sir Temulji Nariman, who shares our surname, happens to be in the Guinness Book of World Records for the longest married life, 89 years. Because he married when he was 5, his wife was 3, and they both went on like good Parsis into their 90s. But coming back to the judgment, Justice Davar, therefore, clearly found that on the evidence, there was nothing to show any conversion had taken place on Indian soil. And therefore, this negative custom was proved, just like infant marriages. Mind you, all this was said by Justice Davar after, in technical terms, dismissing the suit for want of maintainability. This, in ordinary language, only means that the suit as framed and brought to court could not go ahead at all. Now, why could it not go ahead at all? Because the person aggrieved, that is Mrs. Suni Tata, was not herself a suitor before the court. He should have stopped at that. And he knew that he should have stopped at that, which is why he went on to say, however, days and days have been spent on this huge exercise, therefore, if I don't say something about it, it won't look good. Now, Justice Davar's pronouncement, therefore, on its own showing, on the showing of the other judge, and on the showing of the Privy Council later, was what we lawyers term as obiter dictum, which means something which does not form part of the judgment of the court, something which is, in a sense, unnecessary to arrive at the judgment of the court, because the ultimate judgment of Justice Davar was suit not maintainable. The English judge, on the other hand, first held that the suit was maintainable for reasons given by him with which we are not concerned, and then went on to discuss the merits of the controversy. Now, as I told you earlier, interestingly enough, the English judge found on the evidence that yes, there does appear to have been these 3 occasions on which persons were brought into the Zoroastrian fold on Indian soil. But he strongly denied that there is anything like a negative custom in law. He went on to state that if at all there is some custom here, it is the fact that the idea of conversion was ever present to the community in its sojourn in India. Now, how did he say that? He said that because of the very fact that these 3 conversions had taken place on the evidence as produced before the court, and on consulting what are called the riwayats. Now, this is a little important, because whenever we had any difficulties which we faced on religious rites and practices in India, country, that is Persia, and we sent him with questions, and that gentleman came back with answers from the chief priest, let us say, in Yazd. Now, here there are 3 riwayats which speak unequivocally on the subject, and they are all very important. The first is a riwayat of a man called Nariman Hoshang in the year 1478 AD. Nariman Hoshang is sent by the community here, and among the questions that he asks are 2 very important questions. The first is, if slave boys and girls, that is our servants, who are not Zoroastrian, are actually serving us, would it be permissible or proper to admit them into the religion? The answer that he got was unequivocally yes from the chief priest in Yazd. The other question that he asked was, suppose somebody goes out of the religion. There is already a practicing Zoroastrian, and for some reason, he walks out. Maybe he walks into another faith or just walks out. Would it be proper to readmit him? Again, the answer was in the positive. Yes, it is your duty, in fact, provided the various rituals, etc., are properly performed, and provided that gentleman is genuine in wanting to come back. We move on now to the year 1599 AD, where somebody called Kaus Mayyar was also sent with a riwayat. And his riwayat was, suppose we have persons who are grave diggers, that is obviously persons who belong to the Muslim and Christian communities, corpse burners, persons who belong to the majority community here, and darwans. Now, a darwand, strictly speaking, is a person who walks away from the faith. But what was meant here perhaps was Juddin. So the question was unequivocal. The question was, suppose there are persons of other faiths, to put it in a nutshell, and suppose they want to come into the religion, what do we do? Again, the answer comes from Persia. And the answer is yes, you must admit them into the faith, provided no harm comes to Bedins thereby. Bedins being practicing Zoroastrians in India. So this was the second riwayat on this ticklish question. The third was a riwayat of 1773. So you see, it spans quite a period, 1478, 1599, now 1773. And this is called the Itotep riwayat, or the riwayat of 78 different questions. The 13th question, again, was framed in a peculiar way. The question was, suppose you have, perhaps following the first riwayat, admitted your servants into the Zoroastrian faith, would it be correct to consign them to the towers of silence? Answer given again from the chief priest in Yazdis. Not only would it be correct, but if you did not do so, it would be a terrible sin. So, the riwayats as a body of customary law, which may or may not be followed in India, that's a different point, seem also to point to the same direction. The mother country was never wavering in its approach to the religion. And the mother country always stated, yes, you must, but with a few caveats. The most important caveat being, don't do anything that would harm you, because you are, after all, a refugee community here. Now, having said all this, Justice Beeman then goes on, asks himself the same question. Suppose I put myself in the place of the original founder of the trust, what would I do? And says, yes, I would perhaps arrive at the same conclusion. But in saying this, he goes on to say something very interesting. He alone uses the word caste. And he says, because of the majority community here and because we have adopted their ways, like them, we have become a caste. And a caste is something hard and fast, becomes very difficult. It's an exclusive club. Either you are born in it or you are not. And he said that having said this, I must still state that the question really arises on the wrong foot. Because the question arises this way. Do we admit persons much lower to us in status into the religion? Had the question been put the other way, perhaps the answer might have been different. And he puts it beautifully when he says that for every one Akbar that may be converted, there'd be 100 low caste people waiting in line. Therefore, shut the door altogether. Another very interesting thing the English judge says is that if I were to put myself in the place of that founder, and let's say a community of elders in the Parsi community were to, on a case-by-case basis, look at somebody and say, yes, he deserves admittance. Of course, the founder of that trust would admit it. Now, this is so far as the Bombay judgment is concerned. One other very important thing the judgment held, before I go on to tell you what should logically follow or not follow from it, is that therefore now there were three categories of persons who are part of the Parsi Zoroastrian community, so to speak. The first category belongs to those original descendants who came here and their progeny. The second belongs to those Irani Zoroastrians who have come over in the recent past, who will also be given admittance and treated as if they were Parsi Zoroastrian. And the third, and this is very important, Parsi Zoroastrian children that are born of Parsi fathers but alien mothers. Now, the third category was really a great advancement made in the law in the year 1909. And let me tell you why. The judgment of Justice Davar refers specifically to a meeting of the elders of the community in the year 1905. Get your dates right again. 1903 was the conversion of Mrs. Sunitata by a Navjot. 1905 is this meeting of the community, asking themselves whether children of non-Parsi mothers should also be allowed. Unequivocal answer was no, they should not. And therefore, only children born of both a Parsi father and a Parsi mother should be given admittance. 1905. 1906, the suit was filed in Bombay, and 1909 came the judgment. Now, the important advance made in the judgment is the third category. Because despite the fact that the community in 1905, just 4 years before the judgment, said that nobody of an alien mother should also be allowed, in 1909, both judges were agreed that this formed a third category. One very important thing. And secondly, if I were to ask myself the question, put yourself in the place of that 18th century gentleman who founded these trusts. Would he have regarded Mrs. Sunitata as a member of the Zoroastrian Majlis, so to speak? My answer would be yes, and for the following reason. Mrs. Sunitata